Okay, good morning, everyone. In an effort to keep us more or less on time, I think we'll call this panel into session. Now, thanks very much for attending, and thanks, I see Gib in the back there. Thank you, Gib, on behalf of all of us for being a co-organizer of this conference, which is, as usual, terrific. I'm enjoying myself very much. I hope all of you are as well. And I'm very pleased today to be chairing this panel entitled Extradition after Diab. And for those of you who do not know the story of Diab, we will be recounting that story, joined here by Donald Bayne, amongst others, who was and remains Diab's counsel. And also, I'm very pleased to be joined by two of my academic colleagues, Rob Currie and Joanna Harrington. And the bios, of course, you will find on the website. Our focus here is on extradition, which is a deeply international law-related topic, although executed in practice through domestic law, treaty-based, but executed through domestic law. And it's different. Extradition is different from immigration means of removal and also the rather infamous concept of rendition. Immigration removal is conditioned by international law, yes, especially the principles in refugee law and human rights law. Deportation must, of course, not result in torture or maltreatment. Rendition is essentially a black hole, legally speaking. And we do, in fact, have experience with rendition in this country. We could talk a little bit about the Jabara case from 2002 and the extraordinary removal of Mr. Jabara across the Canada-US border by the Canadian Security Intelligence Service. But our conversation today is about extradition, which is defined as the surrender of an alleged criminal, usually under the provisions of a treaty or statute, by one authority, namely a state, to another having jurisdiction to try that charge. It has become a very controversial issue in Canada. We will extradite our own nationals, which is not always the practice in other jurisdictions. And the circumstances in which our nationals are extradited can raise controversial questions. Famously, extradition to face the death penalty, which was a question adjudicated more than 2 decades ago now. And now, extradition in circumstances where you might expect a country to meet fair trial obligations, but which produce a process which appears problematic, at least from, I think, the perspective of many people on this panel. That is the Diab extradition to France. Now, I should note, as we get underway here, that we did ask members of the Department of Justice to attend this panel to present their view. This is a matter of controversy, however, and the Diab case has sparked a renewal within the department and elsewhere, a renewed focus on reform in the extradition area, and so it's not an area in which they felt comfortable speaking. And so with that, I'm going to start a series of questions. I'm going to start with Don, and I'm going to ask Don to outline this now infamous case involving Mr. Diab. What exactly happened, and why is it a matter of public controversy?
Okay, so I'll try in a few minutes to collapse the last 2 decades since certainly a full decade since I got involved, and more than that since this all happened. In 1980, on October 3rd, there was a bomb went off in the Rue Copernic in Paris. 4 died, many were wounded, an act of anti-Semitic terrorism. It was outside a synagogue. The suspect was described as having been a 40 to 45-year-old man. He was traveling on a false passport. By the way, Hassan Diab, who is now the center of all of this, was 26 in that period in 1980. The suspect signed in at a hotel before the bombing, the Celtic Hotel. He block printed the card, the registration card, with 5 words: Panadriu, Alexander, Larnaca, Cyprus, technician. And technician was written in English I-A-N, not I-E-N. He was also, almost comedically, before the bombing, arrested on a shoplifting, a pair of pliers. Maybe they were needed to fix the wires, I don't know, on the bomb. The bomb was transported in a car, a rented car, to a motorcycle which was stationed outside the synagogue. So that's kind of the background about the suspect who was traveling on a false Cypriot passport. Many fruitless years of investigation and intelligence speculation followed that 1980 bombing. Everybody from extreme right-wing German groups to Palestinians and everybody in between figured in the intelligence, trying to figure out who could have done this. The French finally settled on the PFLP, the Palestinian Liberation Front for the Liberation of Palestine, but ironically, that group was a paramilitary group that always claimed responsibility for their operations and never claimed responsibility for this. During the Lebanese, while all this was going on, a guy named Hassan Diab was a student in Lebanon, raised Lebanese Muslim, but going out with a Christian, a Lebanese Christian girl. He lost his passport. This was during the years of the Civil War in Lebanon. And the connection of the French investigation to Hassan Diab, why his name popped up, is his passport turned up in Italy in the hands of a suspicious guy. So he became a person of interest, some guy they thought might have had some connection to terrorism. The 1999 intelligence turned out to be important. That was the fall of East Germany and access by Western democracies to the Stasi records. And in those records, they found an account that, whether it was a intelligence analyst's opinion or otherwise, that the bombers in the Copernic bombing had come from Spain into France. And the first account of this alleged intelligence was they used their real passports to enter France. These were pre-Schengen days, where you have to, every time you crossed a border in Europe, you had to present, there were border controls. So the alleged intelligence said they used false passport or real passports to enter France, and then false passports on French soil. That was later changed, that intelligence allegation, when it was found that Hassan Diab's passport had no entry to France, and so the intelligence assertion was changed 180 degrees to claim that they actually entered France using false passports, and that would explain the lack of any French stamps in the passport, and make it therefore corroborative. The French are entitled to use secret intelligence as evidence if it's allegedly corroborated by some other hard piece of evidence. So that's all background. For 25 years, French investigators, and the French system is such that a juge d'instruction is the investigator, an official of the French government. France's most prominent terrorism investigator never thought there was a case here against anybody. Then a fellow named Mark Trevedick took the case over. They're rotated in and out of these investigative jobs. And he sought to make a case against Hassan Diab. And it was primarily based, he got two graphologists. Graphologists are handwriting people who purport to be able to tell personality from handwriting. It's discredited in the West. In fact, it was used by companies here in the West on job interviews. But it's like nephrology, the bumps on the head to determine who's a criminal. Two graphologists who were deemed experts in the French court system provided handwriting opinions, and they sought to compare the 5 block printed words on that critical hotel registration card with the 1997 application of Dr. Diab to Syracuse University for his PhD. And in making that comparison, they gave an opinion that the author of the application was the author of that handwriting or block printing on the registration card. However, again, comedically, these two graphologists failed to notice that it wasn't Dr. Diab's handwriting they were comparing. It was his wife's. She wrote his application for his PhD. So they identified her as the 40 to 45-year-old man through this handwriting. Those of you who know your history may know that in 1896, a French Jew by the name of Dreyfus, Alfred Dreyfus, who was a captain in the French military at a time when there was rampant anti-Semitism in France, was accused and convicted, again, based on a handwriting opinion and secret intelligence. And he was actually convicted a couple of times, sent to Devil's Island. Émile Zola wrote a famous protest, J'accuse, in French newspapers, for which he was jailed for having had the temerity to write that. And the defense lawyer for Dreyfus was shot in the back during the trial. But Dreyfus was eventually cleared of all of this. And this case bears striking resemblance. The French drummed up these two initial handwriting experts. So based on the handwriting, in November of 2008, Hassan Diab, who was teaching both at Carleton and Ottawa U here, and who had no history whatsoever of any anti-Semitism, his thesis monitor at Syracuse was a Jewish man, and they became good friends. He was arrested at French request, and the dates are important, December 11th, 2008, France, this man Trevedic, who's the juge d'instruction, certified what's called a record of the case. And those of you who know anything, and most people know nothing about extradition, including lawyers and most judges, a record of the case is all that is needed in Canada to make a formal allegation and proof against a Canadian to get him or her extradited. So this document, unsworn, just signed by a French official and making allegations, hearsay allegations, unsworn, as I say, constituted the case against Dr. Diab. He was initially detained at an unconstitutional bail hearing. I was not his counsel. There was a counsel from Trois-Rivières who took on this case, who had a website claiming to be an expert in extradition. And that was when I read the transcripts of it, that was my first experience with this particular group out of the International Assistance Group, who in Canada do all the extraditions, about their zeal. They refused to translate. Dr. Diab does not speak French. The documents from France were in French, as was the record of the case. He could not understand them at his bail hearing and protested that. His lawyer told him, don't worry about it, I understand French. The fact that he, the person sought, couldn't participate in the proceedings didn't seem to trouble either the defense lawyer or the officials for the Department of Justice from the IAG. So he was detained. His wife, Rania Tafaili, came to see me in Ottawa in late 2008, and she is a professor at Carleton, a PhD from an Ivy League school. In fact, the first woman from her village in Lebanon ever to go to university. And we brought an application to the Court of Appeal to quash as unconstitutional, violating fundamental justice, the first bail hearing, which we were successful at. He had a bail hearing de novo here in Ottawa and was granted bail. But incredibly strict conditions, which also required him to pay $2,000 a month for the monitoring equipment that he had to wear for the next 6 years during this legal odyssey. Why? One, because it's extradition, and in Canada, it's viewed as virtually inevitable. And two, it was an allegation of terrorism, which, as you all know, has enormous emotive power in our society these days. So that began a year or two of travel for me. We were up against two of the wealthy, developed democracies of the West, the state of France and Canada. We searched for witnesses to establish the unreliability of allegations in this record of the case. I went to all over Lebanon, Palestinian refugee camps, England, the US, France. And in the course of that, it became increasingly clear there was simply no evidence to support the French assertion other than the sheer bald allegation in the intelligence. It wasn't evidence at all. It just said these guys came in, and nobody knows where that came from. The French admit this assertion came from a foreign intelligence agency, and they don't know who it was or what its provenance was. 2009 and 10 was the extradition hearing. How am I doing for time here?
5 minutes.
Okay. We retained 4 experts in handwriting, chief expert from the UK, from the US, and 2 former RCMP chief investigators in forensic document examination from Canada. First of all, you have to understand you cannot compare block printing with script writing. Forensic document examiners, it's a basic principle. Okay, they were attempting to do here, the French, what was impossible. In addition, they weren't contemporaneous writings, which is very significant. There was a 17-year difference between the samples and the hotel card. And then, of course, these officials proved that the handwriting that was the sample wasn't Dr. Diab's, it was his ex-wife's. However, a replacement handwriting was obtained at Canadian insistence, that while every expert that we retained and we added 2 Swiss experts to the original group, said this was wholly, the opinion of a match was impossible and unreasonable and totally unreliable. The judge found that the handwriting opinion made no sense, was illogical, suspect, and couldn't support a conviction, but because, as he interpreted the law in Canada, he was compelled to extradite. The record of the case that was put forward by France made an assertion that there was no usable fingerprint on that hotel card. Okay, it turns out that was a lie. There was, and the French knew it. The year before, they had, that is in 2007, the year before this record was certified, as handwriting as fingerprint examination techniques improved, they did lift a usable fingerprint from the document that had been handled by the bomber. During the extradition hearing, the Canadian lawyers pleaded with France that the case was falling apart. All of these experts had demonstrated that they weren't comparing Dr. Diab's handwriting at all, but they also asked the Canadians that France send the police statement where this Panelists, the pseudonym, had been arrested for shoplifting, because it had 4 fingerprints on it. And the RCMP would take prints from Diab and compare them. And in the words of the IAG official, this would produce powerful, if not conclusive, evidence to be put before the extradition judge. So they did that. And all 4 prints excluded Dr. Diab. It was not him. And so that evidence was suppressed. It was powerful. It was conclusive, it was scientific, but the IAG did not put that before the judge or disclose it to the defense. Dr. Diab was ordered extradited at his hearing. The Ontario Court of Appeal upheld this, even over the argument that this was not extradition for trial, which is required. Extradition is only to a trial-ready state for the purposes of being put on trial, not for future investigation. And when it was pointed out that France was nowhere near trial and simply wanted this man to continue its 30-plus year investigation, the Court of Appeal dismissed that in a heartbreaking line that reads, "It is clear to us that Dr. Diab will not simply languish in a French prison during an investigation." And for the next 3 years and 2 months, he was in solitary confinement, languishing in a French prison, until on January 12th of this year, 2 new French juges d'instruction, Herbeau and Folzer, did a complete review of the case, traveled to Lebanon, examined the University of Lebanon records and interviewed witnesses there, found overwhelmingly consistent evidence that Dr. Diab was nowhere near France. He couldn't possibly be this guy, apart altogether from the fact he was 26 and the bomber was 40 to 45, and none of his fingerprints matched. It was not him. He was in Lebanon writing his exams, as he said he was, and had nothing to do with this. They ordered the investigation stopped and him released and sent home. They'd tried to release him 8 prior times. When they closed the investigation, even though the prosecutor appealed again, they couldn't stop the release that time. They had stopped at 8 prior times. He came home to Canada. There are appeals now pending in France. The Court of Appeal in France has just, in what, the 38th year since this happened, and now after multiple I would say embarrassing moments for French handwriting expertise, has ordered another French handwriting to try and bolster this case. So Dr. Diab remains, although teaching here at Carleton, I was at his class just this week, in a strange legal limbo, and our Extradition Act and process remains to this point tragically unexamined.
Thank you very much, Don. Joanna, do you want to take 5 minutes and react to the Diab story?
Of course. Yes, I'm going to say this. I'm going to say for me that the Diab's case brings home what's the starting point in extradition law, and that is that extradition should be guided by principles of fairness, transparency, balance. I also believe that Canada's extradition relations should reflect a principled approach to foreign policy. And for me, a principled approach for foreign policy includes a commitment to the protection of our most basic, fundamental human rights. So what am I getting at? Well, part of the balance, part of the fairness is the need to consider the rights of the individual at the center of this extradition request. Extradition is not simply a question of aisle seat or window. It's actually a question of looking at an individual's liberty rights. And in this case, it's a Canadian's liberty rights that are at stake. The Supreme Court of Canada has made clear there are 2 purposes, not one purpose to extradition. Yes, it's a means of Canada's compliance with its international obligations to secure efficient crime control cooperation in the fight against cross-border crimes. But it also serves to protect the rights of the person involved. So we need to have a human rights protection analysis in each and every case. The Supreme Court of Canada has recently said that in India Badesha. I agree with that. I have criticism of that case. So what's the human rights at stake here? Well, one of them is a right to a fair trial. A right to a fair trial in a reasonable time. It is simply unacceptable to sit in jail for 3 years on a pre-trial basis when one has been extradited for the purpose of standing trial. It's also contrary to our rights to a fair trial for information tendered as evidence which a Canadian extradition judge finds to be unreliable. That also goes to the fairness of a fair trial. So we've had holds on extradition if there's a real risk of facing ill treatment, But, you know, the European Court of Human Rights back in 1989 said that gross violations of a right to a fair trial should also bar extradition. So for me, the reactions here is going forward, I think we have to learn from the Diab case to have more extradition treaties have provisions for expeditious trial post-surrender. I've done a check. I can find two. There's one, Canada and the Philippines, says expeditious. And our treaty with India requires the trial to occur 6 months after surrender. So that's one reform that I think this case says is concrete obligations for post-surrender. If it's surrender for trial, the trial should come within a reasonable time. Delay is endemic in extradition proceedings. And at some point, I think the spirit of Jordan is going to start to have an application to extradition proceedings. The fact that Dr. Diab has been under this cloud for how long? It's an appalling length of time that's taken both pre-extradition, now surrender, now post-surrender and back to return to Canada. So I think, you know, we need to have the case itself opens up this question of reform of extradition law. I would like to have it look broader than just the Dr. Diab's case. That's not to say his case isn't important, but I think there's some other things going on in extradition law, like this assumption that all of our extradition partners have been vetted and there's been a human rights appraisal done of them. You know, if you just count of the 31 countries listed in the schedule to our Extradition Act, just do a Wikipedia search, 11 of them have had coups at some point in their time. Now, admittedly, that may be in the early times of the period, but we're still extradition partners with Solomon Islands, Zimbabwe, Maldives, right? Countries with relative instabilities, I'll say, before I insult someone in the audience from one of those three countries. My apologies there. So I think some of our extradition treaties are very old. We are relying on an assumption that we vetted them. And the fact of the matter is Canada today commits human rights violations. So why do we not have this approach of saying at the very heart of an extradition case is an individual's right to liberty? And that requires a human rights appraisal then and now at the time of the case. Now, with respect to France, because some will say, well, Joanna, this was an extradition to France. We have seen that France has a difficult problem with a trial within a reasonable time. In fact, we see reports from public monitors for the cases that have been transferred from the International Criminal Tribunal for Rwanda. They were transferred to France for their jurisdiction, and there have been monitoring reports, post-surrender monitoring reports, pointing out the delays that seem to be endemic in the French system. So it's not like we were unaware of a past record in post-surrender context of delays. I'll probably leave it there. I could perhaps say more. I think there's also a need for cooperation between justice and global affairs. I think at the end of the day, this is an extradition to another country. The department within our federal government that statutorily has the expertise on what's happening on the ground in another country is Global Affairs Canada. Our Extradition Act makes the decision to surrender solely the decision of the Minister of Justice. I think one reform would be to make it a consultation obligation of the Minister of Justice with the Minister of Foreign Affairs. There is actually a consultation obligation with the Minister of Immigration and Citizenship if an extraditee is also alleging refugee protection. It seems to me there's a broader issue at stake here about what are our current human rights obligations both for Canada and for our extradition partner. Governments change, practices change, problems arise, and I think we have to have a current assessment in each and every case. Thank you.
Thanks, Joanna. We're going to come back to you in another round, but to put a pin into two questions I have, should Canada be supervising the judicial system in a country that is subject, for example, to the European Court of Human Rights? So a different environment. And the second thing, if we're going to use delayed trials as an indicator of when we shouldn't extradite, what does that mean about extraditing people to Canada? Rob, your 5 minutes.
So in a way, I'd like to say, everything Don said, everything Joanna said, and I think it's tragic that the government of Canada is not here at this table today. And I want to repeat what Craig said. They were invited. The International Assistance Group was invited to appear. There are always two views to every situation. And as an academic, I want to have both of those balls in the air. But they're not here, despite the invitation. So for one moment, let me be amicus curiae for the IAG, just for a moment. This panel is about the profound problems in our domestic extradition law. But if we zoom out to 10,000 feet, it's good to remember that extradition is an important process. It's a necessary part of the fight against global transnational crime, now more than ever, because there's more global transnational crime now than there ever was, and it's increasingly a problem. So we need an extradition process, obviously. We need it to be good. We need it to be effective. We need it to be fair. We need it to be efficient. And, you know, to put the shoe on the other foot for a moment, when Luca Magnotta committed his horrific acts in Montreal and fled to Germany, we wanted to get him back here so that he could face justice. And we got him back because we had a good extradition relationship with our European partners, including Germany, from where he was extradited back to Canada. So extradition is important to all of us because the fight against transnational crime protects all of us. It's, you know, vital Canadian interest. So we need to have a process. We need it to be a fair process. And when and if extradition is going to be fair, it turns largely on what the domestic extradition law is, which is the focus of our inquiry here today, really, despite the fact that it's infused with international law practice and international law principles. Much depends on what the domestic process looks like, which in our country is under the 1999 Extradition Act. And the 1999 Act was deliberately designed to make extradition from Canada easier. And I guess I've still got my amicus hat on here. It needed to be easier because our pre-99 extradition process was messy. It involved two different courts with varying jurisdictions. The federal court was in the mix for some reason I still can't figure out, even when I look back at the older cases. It was messy. It was time-consuming. And in particular, states requesting extradition who didn't come from a common law tradition had a great deal of trouble navigating our system. There are legal concepts that we have that are not known to other jurisdictions, like even the idea of sworn documents. Like some jurisdictions don't have that concept. You say to them, I need a sworn affidavit. And they say, what is sworn and what is an affidavit? Right? It's just not resident within their system. So the 99 Act was designed to facilitate extradition with states that had different legal traditions and try to make the things map onto each other, including France, which is a civil law-based jurisdiction. And in policy terms, that's a good idea. And it was a good idea. Now my amicus hat comes off, and I say that Don has helped us realize how the Diab case highlights the profound problems, the fairness problems, in how our system executes extradition here from Canada on the domestic level. And it's worth mentioning, too, that in 2002 in the Queen's Law Journal, Anne Laforêt published an article on what was then the new Extradition Act, and she foresaw all of this. You go back, I've never read a more prescient article, historically speaking. She foresaw exactly the problem that we're going to dig into, I think, which is the lack of meaningful tools in the hands of the committal judge. Power was taken away from the courts and injected into the jurisdiction of the minister. And the fear that Professor Laforêt raised was that the courts in this process were going to end up being a rubber stamp kind of process, and they have been. Despite efforts by lawyers, despite effort by the Supreme Court of Canada in 2006 to turn that back, that is the problem. The record of the case approach in particular, as Don has highlighted, is what causes issues. So, problems. Joanna referred to the problems in the French system. They should not be de-emphasized. Our presumably good extradition partner in France would suggest a very large problem with politicization of terrorism prosecutions. People who practice in France will tell you in hushed tones that there are other endemic difficulties in the French criminal law system. So we've got that to do. I don't know what the French translation for Keystone Cops is, but this case certainly is redolent of that phrase, all at the cost, at the human cost, to Hassan Diab and to his family. And, you know, Don can speak more eloquently to that than I can. I guess I'll close my opening remarks with this. the tragic line Don referred to in the Ontario Court of Appeal saying, well, he won't molder away in a French prison. The Minister of Justice, when the new act was being brought in, stood up in the House of Commons and said that wouldn't happen in 1999. And it did. And it's endemic in the structure of the act. I mean, that is the problem. And the Diab case, I think, as well, finally highlights what we can only describe as the ferocity with which the Crown pursues extradition from Canada in this country. From a policy standpoint, apparently totally geared to facilitating extradition for our extradition partners. Again, in principle, a good thing to do. Clearly, there's a lack of balance. And that's, Diab is what brings that into sharp relief for us today.
Great, thanks, Rob. When we come back to you, I have a couple questions for you as well, which is the problems you've alluded to are probably problems you could identify with each partner, although the partners may vary. And so if we had Conrad Black on this panel, he'd say some things about the American system of criminal justice and the extent to which there's full disclosure. I would also raise the issue as well, are we going to get into mini trials in Canada, where you have to do basically a proxy of a criminal trial before you extradite? And then, of course, there's the reciprocity issue, which one of the reasons why the Justice Department might be quite fierce in advancing cases involving extradition of Canadians overseas is for fear that if they don't, what's good for the goose is good for the gander, and other jurisdictions won't cooperate with us. So just a pins in those issues. Don, I want to come back to you. So we've heard a little bit from Rob and Joanna about the sausage factory that is the extradition process. You've been closer than most because of your work over the last more than a decade now, which was non-remunerative. And so congratulations to you in the highest spirit of the profession, I have to say. What do you also mentioned that Canadians don't know anything, lawyers don't know anything about extradition. If you were to identify something you want these people to walk away with today about extradition law, what would it be? What is it that you would single out is the greatest thing that you worry about in Canadian extradition law?
Okay, so Craig, it's a combination of what you heard Professor Harrington and Professor Currie mention. Number one, the Canadian Extradition Act and process devalues liberty despite Section 7 of the Charter. And what do I mean by that? Recently retired Chief Justice Beverly McLaughlin in a speech said, liberty is that most precious thing without which everything else is worthless. The Extradition Act, however, presupposes an expeditious and summary procedure. And our moderator has raised the question of, are we going to have mini trials? Well, what we have now at the other end of the spectrum is a greased lightning, inevitable process that is wrong and unjust. So the starting point that extradition has to be and must be summary and expeditious when liberty is at stake is wrong. Think about it for a minute. Section 7 liberty, protected for all the Canadians in this room and all people in Canada, is important in the domestic context. But it's even more imperiled in the extradition context. Because if you're imprisoned here, if you're charged here, and you're more likely to get bail here because you've family here, right? And your supports here, and you know the system and the language. Dr. Diab didn't speak French. When he was sent to France, he was put into a different culture. He couldn't communicate with the others in France's largest prison. He knew none of the locals to try and retain a lawyer. So you are sent far from home, far from your family, far from your supports and friends, and into a totally new culture. That is a graver impediment to liberty, and that's the first and foremost failure of this system, that, well, we're going to make that graver intrusion on liberty easier to do, expeditious and summary. Secondly, there's no sworn evidence required. It's simply an unsworn allegation of some foreign official. That is wrong because of the third factor. That unsworn allegation under our law is presumed to be true. There goes the presumption of innocence. There goes our normal rules of evidence in our system. Even sworn evidence is never presumed to be true. It has to show its own reliability. But the presumption of reliability of the assertion in the record of the case is fundamentally wrong. Then you add to that, what has happened in the courts is the incremental, and Professor Forcese, I think, mentioned the 2006 attempt by the Supreme Court, or Professor Currie did it. You know, the Supreme Court failed Dr. Diab, too. Yes, in 2006 in Ferris, they said, we will not extradite on unreliable evidence if the person sought can show the evidence is manifestly unreliable, he or she can resist extradition. Well, what do you call it when all the sworn evidence says this handwriting is totally unreliable, not marginally, totally? We used the wrong methodology, not accepted in the field, the wrong samples. The judge says it makes no sense. It's because the courts have created a maze with no exit here. Nobody can prove manifestly unreliable, the standard that's been set. So the burden's been put on the person sought, the onus in the proceedings, which is also a major shift. Add to that there's no requirement that the foreign state make full disclosure of all of the evidence. They can cherry pick. So France, when Mr. Trevedick was writing this record of the case, he didn't have to put in, by the way, we have a key fingerprint here, and it's not him. It's right on the bomber's card. He went even further. He said there is no usable fingerprint. I mean, and there's no, he can say that with impunity. There's no penalty under Canadian law here. So, and then you add this concept of that you've heard about this morning, that extradition is allegedly justified in Canada based on the principle of comity. They will do for us what we ask them to do, we are asked to do. The problem is France will not and would not extradite a Diab from France to Canada if he was a French citizen. They will not do that. Comity can, it's a false justification. It's just overlooked. And then you've already heard the final problem. We're now extraditing for foreign investigation. That's what happened to Dr. Diab. So it's a constant, it's not any one thing, it's a toxic brew of unfortunate features of this legislation and process that is profoundly unfair. The author of the leading text, Gary Botting, Extradition Law in Canada, begins the text, this is a legal text, with the sentence that this is a text about the least fair law in Canada. Just think about that. A legal text that begins with that. And it is, and it's been unexamined, and my theory on it, it's just a personal theory, is this is such a backwater of Canadian law that all of those Court of Appeal judges we were arguing to, they'd never done an extradition. 90% of the Supreme Court of Canada judges, with the exception of the late Justice Laforêt, had never done an extradition. And he wrote the extradition law, and guess where he came from? The International Assistance Group. And so they don't know, they just expect, they treat the IAG as the true experts. They do know more than most Canadian lawyers about extradition. It's their narrow specialty. And we've allowed that one group and its demands and their zeal to take over Canadian law at the expense of constitutional fairness.
Great. So one thing I want to have someone address at some point in this point, I'm going to wear Rob's amicus hat here, is the question of extradition of your own nationals. We will extradite our own nationals. Then again, most of our criminal law is territorial, not extraterritorial. And so the European jurisdictions, which won't extradite their own nationals, often their criminal law will reach extraterritorially. So the risk, of course, is a gap, and you want to make sure you don't have impunity. So if we had a system where we declined to extradite our own nationals, would we have to extend our criminal law extraterritorially to avoid impunity by our nationals for their overseas conduct? All right, so Joanna, so you talked about the post-extradition consequences in terms of delayed trial and the like. And I want to broaden the ambit a bit beyond the Diab case and talk about international practice generally. And I think lurking in the background of this conversation has to be the prospect of an extradition treaty with China, which is in the ether. It's being discussed. We now have removals, immigration removals to China for non-Canadians, that is Chinese nationals who are in Canada. Those have been controversial. We've had diplomatic assurances issues arise there because of fair trial concerns in China. If we move to an extradition treaty, we're suddenly opening the gate to Canadian nationals now being removed. So what do we learn about the broader international practice in the area of extradition for Canada?
So I have spoken before about China, so since you've mentioned it, I'll put my two bits in, which is just to say, how can you have an extradition to a country with a 99% success rate in terms of trials, and what is the fairness of the trials there? It's pretty well a foregone conclusion with respect to Chinese trials. I'll also mention that in Australia they had signed but had not ratified an extradition treaty with China. The Australian Bar Association made submissions very much concerned about both the treatment of individuals who would be sent to China as well as the fairness of the trials. So those two themes keep coming up, is both mistreatment, whether it's death penalty or torture or other forms of serious mistreatment, as well as gross violations of a right to a fair trial. But I think the short answer to your question is that we need actually post-surrender monitoring and reporting back. It's actually hard to know what's happening because we don't get status reports. And I'm not the only one to point this out. The Australian Parliamentary Committee has actually made this recommendation several times, that we need to see status reports back to the sending state saying what happened after extradition, what happened after the surrender. Did the individual face trial? In fact, go on trial? And what was the outcome? What was the timing? You know, and I'd like to see these reports go to Parliament so that we have this data on who surrendered, what date, where, was there in fact a trial, and what was the outcome of that trial. I'd also like to see these post-surrender monitoring and reporting back cover conditions of detention, right? Both pre-trial and after trial. I'd like them to be part of the terms of an extradition treaty, that our post-surrender obligations continue, right, with respect to actual terms in the treaty. I think, to me, that's part of modernizing extradition law, right, would be to include terms on post-surrender monitoring. And by the way, again, we could learn from international criminal justice more broadly. We have post-monitoring provisions in sentencing agreements with international criminal trials and the country with where a sentence is going to be carried out. So it's not like we can't cut and paste. There are available examples that can be used. We're going to probably get into this issue of conditions and assurances and what can we provide, you know, that will ensure the fairness of both treatment and trial for an individual after surrender. So I'll just put it out there to say the issue of diplomatic assurances, and just to say, look, the European Court of Human Rights and now the Supreme Court of Canada has made clear that assurances by themselves are not sufficient to secure adequate protection. And so that's why I'm getting at, we need consular monitoring reporting back, we need independent international monitoring and reporting back, and frankly, there needs to be an understanding of international human rights law, that there is law in this area, not just extradition law, there's also human rights law, and the two are working together in this area. Now, I could talk a little bit about extradition on assurance. I'll just say, because it links to your point about, well, what's the role for the European Convention on Human Rights? You know, and I'm one who has said, look, it's a factor that goes to the reliability of the assurance. And hence, I have criticisms of Supreme Court of Canada jurisprudence allowing Canada to extradite to a country that is not a party to the Convention Against Torture. For me, yes, the human rights ratification is relevant to the reliability of our assessment of what's going to happen post-surrender. If you're wondering what that country is, it's India. You know, and you're up there with Angola and Sudan and, sorry, Zimbabwe, I've hit you twice today. But, you know, countries that have not, it's a small club that hasn't ratified the Convention Against Torture. So, you know, and also if you go further, if you want me to talk further about the facts of that case, but just to say they've been promising for 20 years to ratify, that also suggests a concern about the reliability of an assurance, oh, don't worry, be happy, they're going to be fine post-surrender, if obviously you can't fix what's ever in your domestic system that's holding you back from ratifying what I would have thought would have been one of those kind of key treaties. And also, I'll put it on the table, I'm one of those individuals who would say, as part of our foreign policy, I don't think we should be extraditing to a country as a matter of principle that's not a party to the Convention Against Torture. So don't get me wrong, European Convention, ICCPR, whatever treaty it is, it's not you know, a guarantee of fair treatment, but it's one factor in reliability of the assessment, the human rights appraisal. And, you know, it's not a pass. I don't want it to be window dressing, but it is one of those factors that we can look in. The last thing you pointed about territoriality, I'll just say that I really do not want us to return to our sort of old safe havens argument, you know, this idea if you don't extradite, they're going to get off free and wander the country. The extradition to India case is a good example here. It's a case, for those not familiar with it, involving two Canadian citizens who are alleged to have orchestrated essentially a killing, orchestrated a killing from Canada, based in Canada, never leave Canada, to kill a third Canadian citizen in India. So where is the territory where that occurred, where that crime occurred? And so that's the problem I have, is that often we have, I think, very traditional view about prosecution of crime on the territory, when that would be an option, is two Canadian nationals could have been tried in Canada for the orchestration of a killing that did take place abroad. The extradition judge in that case records the evidence available. It's like 220 hours of phone calls to show the orchestration here of that killing. For those familiar, or for those from British Columbia may be more familiar with the case, but it's the killing in 2000 of Jazzy Singh. It's now 2018, and there still remains no justice in the form of a trial for Jazzy Singh. So there could have been a prosecution in Canada in 2001, 2002, you know, pick your date, as opposed to an extradition request in 2012 that went all the way up to the Supreme Court of Canada, and now it's 2018 and we haven't extradited. So I'll end with that point on the territoriality, that there is an option, and that's, think about a real and substantial connection to Canada in terms of determining territory, if you want to stick within your territorial view. And also then, you know, I know human rights people will be a bit upset if I say this, but I think nationality matters too. And that's not to say that we don't have human rights because we're human, but we also, as a national, I think, have that additional reason to think further about other options.
Great.
Thanks.
So the Libman case, in other words, is
Yes.
your, yeah. So we have enough time before questions for one more round. So Rob, why don't I turn to you? Joanna has outlined some improvements to the treaty regime and then incorporated into our domestic legal system. Of course, in a bilateral treaty, there are two parties. How will this affect our bilateral relations?
It's going to require work. It's going to require work on both sides, because you mentioned the principle of reciprocity earlier, Craig, and that's so important for there to be meaningful, effective criminal cooperation. We are dealing with other sovereign states with criminal law systems that are different from ours, and that's always been the terrible beauty of this process, that it works at all when you're in some sense marrying criminal law and regulatory concepts between jurisdictions. So there's heavy lifting to be done, and there's hard work to be done, because we do need to maintain that effective network of states who will help us when the Luca Magnotas and people like that escape and need to be extradited back to Canada. I mean, there's no doubt about that at all. But the heavy lifting, I would say the heavy lifting we have to do at this point is fixing aspects of our domestic extradition procedure that, you know, that constitute some of the machinery that provide the cooperation. And just as a couple of examples, Joanna mentioned the presumption of good faith, and this is how reciprocity is embodied in a sense in our system. It's essentially presumed in Canadian extradition law that any state with which Canada has an extradition treaty is a state that can be trusted, right? That's a state that the executive in particular has satisfied itself that having done the necessary legwork, that this is a state that we can safely send people to, no doubt about it. And the courts also are convinced of this. And this is why I say it's a presumption. to teach you evidence law for 15 seconds, that it operates like a presumption. The fact of a treaty leads to the presumed fact that there's good faith and we shouldn't have any worries about the requesting state, and it falls to the individual sought to overcome that presumption. And the courts have cottoned on to that. The reason they've cottoned on to that is that the executive keeps telling them this. That's as I read back through the case law, it amounts to that. And yet, look at the states with which we have extradition treaties. Joanna mentioned a few: Thailand, Mexico, India, Argentina, Russia, Liberia, Colombia, Romania. That's not a law enforcement network. That is a rogues gallery of states known for human rights abuses. And you don't have to ask me. Ask Amnesty, ask Human Rights Watch, ask the U.S. Department of State reports on each of those countries. Which is not to say, again, we can't have extradition relations, but there is legwork that needs to be done. Yet, in our law now, there's a presumption that that's okay. These states are okay. And it feeds, this is part two of this problem, if you can believe it, it feeds a traditional common law idea that the courts need to be deferential to the executive when you get anywhere near the prerogative power around foreign relations. You can't, if you're a judge in a Canadian court, you can't be messing around with international relations, making judgments on how foreign criminal systems operate. You leave that to the minister. And that is a traditional concept, arising from longstanding common law traditions. The problem here is that the minister, as we've seen post-99 Act, is really only interested in extraditing, for the most part. I'm speaking in only slightly hyperbolic terms, for the most part. And this is something we haven't even touched on, the minister in this setting gets the most deferential standard of review known to administrative law in Canada. If any of you are administrative law experts, tell me a more deferential standard of review than the one the Minister of Justice gets in extradition. There is not one.
We'll wait and see what the Supreme Court does with its trilogy.
Yep, we will see. But in the meantime, if there's a scale, it's over here. It's on this end of it. So I say that's not acceptable in a state like Canada that has constitutionalized human rights protections that allegedly, anyway, implement our obligations under the ICCPR as well. So I think one way we start to do the legwork is we peel that presumption out of our law so as to try to reduce some of the unfairness on the individual sought and have those difficult conversations with our treaty partner states that we need to have. And they are difficult. The European arrest warrant system, which is, the sort of much ballyhooed solution to extradition problems, is falling apart. Funnily enough, now it is, mostly having to do with Poland these days, but it's beginning to unravel. So these are hard conversations. It's difficult stuff, but the work has to be done. The only other thing I'd mention is, how are we doing for time?
Very quickly, and then I'll come back to Don.
Okay, very quickly. Joanna mentioned this, averted this, Section 6 of the Charter. Canadian citizens have a right not to be extradited from Canada, in fact, but we say it's saved by Section 1 because extradition is such an obviously good public policy goal, which it is. In cases where, like Badesha, where either Canada or the requesting state could prosecute, there's something called the Catroni assessment, which is done. And the idea is the court looks at what are the connections of Canada, what are the connections of the requesting state, in order to meaningfully assess whether the individual is going to enjoy their Section 6 right not to be sent out of the country except by compelling force of law. That exercise is hollow. It's completely formalistic. The individual sought in Canadian extradition law never wins the Catroni question. It's a completely stacked, meaningless process. And it's because prosecutors talk in the background and decide well in advance. If there's an extradition request, it's because Canada has decided not to prosecute. So that's an empty, meaningless, hollow Section 6 protection is not a protection at all. So that's another bit of machinery we need to try to inject our relations with our foreign partners with a meaningful sense of fairness.
Great. So, Don, I'm going to ask you, we've been talking a lot about prospective reform and best options. There currently is a discussion about reform, or at least a reaction to the Diab case taking place at the Department of Justice. Murray Siegel's been brought in. This is the second time in recent history Murray Siegel's been brought in to look at justice practice. A year or two ago, he was brought in after justice got slapped around a bit by the federal court for failing to disclose properly in ex parte in-camera proceedings in national security. So there's this vetting process underway. I don't know what's going on there, though. So do you have a sense in terms of where Justice Canada and Global Affairs, perhaps others, might be going in this space?
No. On January 12th, when Dr. Diab was released, and I'm not totally critical of the government, Minister Freeland, in my view, was absolutely outstanding. We met with her personally before the release. She and her consular staff in Global Affairs got Dr. Diab home immediately. She was deeply professionally and personally committed to the justice of his case. And the Prime Minister on his return went public and said, we're going to get to the bottom of, and he used the word exactly what happened here, what went wrong, because what happened to Dr. Diab never should have happened. We misinterpreted that to mean, but we weren't the only ones, Amnesty International, BC Civil Liberties, Criminal Lawyers Association, Canadian University Association of University Teachers, and a bipartisan trio, former Prime Minister Joe Clark, Ed Broadbent, Monique Bégin, all wrote publicly in the Globe and Mail about the need for a public inquiry in this case. And it's a matter of public concern. The Extradition Act does not affect only Dr. Diab. It's all Canadians. What went wrong here? What went so horribly wrong, and what's wrong with our system? The problem is the government has, as Craig has alluded to, I don't know what's going on. You don't know what's going on. I've communicated with Mr. Siegel. We've pleaded for all the aspects of a public inquiry, which means an impartial judge, not a prosecutor working out of the IAG office, who has the power to compel documents and witnesses. That is, witnesses have to come and be sworn and be subject to examination and cross-examination. Under these terms of reference that Mr. Siegel's been provided with, Canada and France can decline to produce documents to him if they deem them that it would impair international relations. Well, I'm sure there are documents there that France and Canada both don't want revealed. The public is not going to know. Canadians are not going to learn. There's no transparency to this process. And there's critically no jurisdiction that's been given to Mr. Siegel in this, what they call an external review. It's internal and it's behind closed doors. There's no jurisdiction to examine the deficiencies of the Act and to recommend reform. What's wrong with Diab? One, the Act and its processes. Two, conduct of IAG officials. Three, conduct of France. None of those can be examined. So why have this behind closed doors except as a political damage control to say, with not going to offend France, not going to offend this powerful insular group in justice. Don't forget, the minister doesn't really write those surrender reasons. Guess who does? The IAG. The ministers don't know extradition except they're told by their expert group. And so when the minister answers, in our case, we wrote an 80-page submission as to why Minister Nicholson ought not to, and it would be unjust for him to surrender, notwithstanding the committal for extradition. We got an answer that over his signature, but he didn't write that. The very group that we litigated against, who were arguing for his surrender and committal, wrote it. We're never going to learn under the terms of reference that have been given anything to quote the Prime Minister, exactly what happened. And so far, that's the tragedy. Whether after an election, the government, if they're still in power, will feel, okay, they've got the political capital now to do this, but politics is playing with this case and with extradition.
Rob, I want to get to questions, but I want to give you the last word on independent law reform effort, which you've been very busy. Do you want to talk a little bit about that work?
Sure. A group of us, I'll be very brief, but a group of us has come together to try to formulate something like meaningful extradition law reform proposals. And very fortunate to have Don's participation, also Professor Harrington's, and a number of other experts coming from various camps. There needs to be a meaningful law reform package put together. And we had a very fruitful discussion in Halifax back in September. We had representatives of Amnesty International, BC Civil Liberties, and the Extradition Defense Bar. The federal government was not there because we're going to present this to them eventually. There is an ongoing process where we're going to develop a fulsome set of proposals to engage what we think is necessary, which is law reform. Again, nobody wants to. Well, I don't. Nobody wants to scrap extradition here. We need extradition, right? But our process has got to proceed along the lines and the principles Joanna suggested earlier: transparency, fairness, and we think a significant rebalancing of the roles between the courts and the minister in the process. And I could talk for another hour about that, but we're still in process.
Great, thanks. All right, questions.